And this morning on the Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you.
Good to be with you as well. And up in Jackson County on your farm, you've been seeing snow this morning as well.
Yeah, probably a couple inches. I'm actually in Shawnee, but I'm right up tucked in under the line in the corner of Jackson and Jefferson. So a couple inches of light, fluffy snow. Just was able to take a snowblower out there about an hour ago and blow it out. Blow it off. It wasn't bad, but it makes things look pretty again. Removes all the dust and the dirt and that were on the piles and so forth, and gives us a nice coating.
Yeah, absolutely. All right. This time of year, of course, we talk our your top 10, not my top 10, your top 10 list of the agricultural law and tax developments of 2024. A busy year, to say the least. And let's start out right at the bottom of the list, number 10. That is the, in this case, states' water compact that must include the federal government, talking about the Rio Grande Compact.
Yeah, that's right, Greg. This is a compact entered into between Colorado and Mexico and Texas, and that was entered into concerning the Rio Grande in 1938, and Congress gave approval to it in 1939. Well, things have changed since then in terms of water withdrawals and agriculture development in those areas, and it started affecting surface water. And so Texas was thinking that it wasn't getting enough water under the compact, sued New Mexico for allowing basically water reserves to be channeled away from Texas, which deprived it of its share of use of the Rio Grande waters. So those states entered into a compact, an agreement, and we're familiar with those in Kansas. Of course, there's been the Kansas, Nebraska, Colorado compact that was entered into a number of years ago. And they tried to do this on their own, and the U.S. Supreme Court told them back in 2018, no, you can't just do this by yourself. The federal government has to be a party to it because the federal government has a treaty obligation to deliver a certain amount of water of the Rio Grande to Mexico, and because the water was delivered by a federal reclamation project administered by the Department of Interior. And there was some interest of Indian tribes, too. But the states went ahead and did that. They got sued. Even after the Supreme Court told them you have to bring in the Congress to this, there is a constitutional provision that's pretty clear on this. Article 1, Section 10, Clause 3 says, no state shall, without the consent of Congress, enter into any agreement or compact with another state. So when the federal government has an interest in a water agreement among the states, it has to be a party to the agreement. And that is indeed what the U.S. Supreme Court said again in 2024 and invalidated this agreement, sent it back to the water master that had been appointed in this one, which is basically a jury of one. It's a special water master, and they'll figure out how to bring the federal government in and get a resolution. And Greg, I think the big deal about this one is that is very significant in terms of water rights throughout the western United States, where the federal government is going to likely have to be a party under the Constitution in a lot of these agreements amongst the states. And water issues are perhaps the top issue, if not the top, but one of the top 2 or 3 issues in the western third of the United States.
We move to number 9, going from water to the public lands rule, and that, of course, talking about in the western United States, or in this case, a case in Alaska.
Yeah, Alaska and elsewhere, there have been a lot of lawsuits concerning this. What this is that the BLM published a new public lands rule last May, and it's part of the previous administration's effort to conserve at least 30% of U.S. lands and waters by 2030. And it's projected, if it's upheld and goes into effect, it'll apply to about 245 million acres of public lands, which is about a tenth of the U.S. land area. Well, we've had multiple lawsuits filed against that. And basically what this is the way that the public rangelands are to be managed. And it takes away a lot of, I'm oversimplifying things in terms of time here, but it's taking away a lot of grazing rights for farmers and ranchers, I should say, that graze on public lands, which they have to use in the West. because the federal government holds so much ownership of that land. And the rule prioritizes land conservation through restoration and mitigation by restricting grazing on public land. So it's being challenged as exceeding the government's authority under the Federal Land Policy and Management Act because it's setting aside land for conservation, which is a power that Congress has reserved for itself, is the claim. And I think that's probably a pretty good claim. And the claim is that it's vague in when land can or will be set aside for mitigation or restoration. American Farm Bureau has also filed a lawsuit on this, and we'll see where that goes in 2025. So I expect grazing issues to be big in 2025, and perhaps the change in administration will minimize the disputes on the federal rangeland.
Number 8 is talking about the takings cases at the U.S. Supreme Court, and basically how you frame it is the Constitution self-executing?
Well, that's indeed one of the cases involving a farming operation in South Texas near the Gulf of America. And in that case, the family had farmed the land, same land, for over a century, and there was no problem with flooding until the state renovated a highway and changed the surface water drainage, and that turned the highway into a dam. And so when tropical storms would occur, the water no longer drained into the Gulf, and that farm was left flooded for days. It destroyed cattle, destroyed crops, killed their cattle, and they sued the state of Texas on a takings theory to get paid for that. Well, the state said, you can't sue us because the statute is not self-executing. In other words, there's no built-in cause of action. And they said, well, the state can sue for a taking, but you can't as a private citizen. And, of course, the farm family thought that was crazy. They went to the Supreme Court, and the Supreme Court took the case and agreed with them and said, well, it's not a taking claim at the state level. It's known as inverse condemnation cause of action. That's how you recover lost value by a taking. There's a lot of really interesting procedural things in that. That's just kind of the techie stuff in this. But that's the basic point. You do have a right under Texas law, as you would in Kansas and elsewhere, to file for an inverse condemnation when the state takes your property. That's one of them. Another one occurred out in California where a person wanted to build a home on their land kind of between Sacramento and Lake Tahoe. So that kind of frames it for people in their mind as to where that's at. Beautiful drive, couple-hour drive on that route there. And they said, well, you can do that. It's just a modest residential home. But they said you're going to have to pay a traffic impact mitigation fee. And the landowner said, no, wait a minute. No, that's extortion. You're extorting that out of me. And I think there are prior cases of the Supreme Court that say that you can't do that. This case gets all the way to the U.S. Supreme Court, and the landowner was right. That $24,000 fee was unconstitutional. And the Supreme Court ruled unanimously in the landowner's favor. There's nothing in the takings clause indicating that it doesn't apply to fees imposed by state legislatures. So another property rights case at the U.S. Supreme Court.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, here on the Ag Issues program on 580 WIBW. Roger, we're at number 7, and of course a very familiar one, and one that I think has made the top 10 for quite some time, and that of course is the latest developments on waters of the United States.
That's right, and I'm not going to focus on the reg itself, but we had a significant case out of Idaho in 2024, following up on the Sackett opinion from the U.S. Supreme Court in 2023, where the court gave us a more refined and I would view it as correct interpretation of what is a water of the United States. But we had a ranch in central Idaho that was charged by the EPA with illegally discharging pollutants by constructing road crossings across the Bruneau River, which is a navigable water, and associated wetlands, which the EPA claimed impeded the flow of the water and polluted the river. And the ranch sought to dismiss the case for failure to state a claim, saying the EPA didn't sufficiently specify in its complaint that the wetlands at issue had a continuous surface connection with the river, which continuous surface connection comes out of the U.S. Supreme Court's definition of what is a regulable wetland under the Clean Water Act, and it's required to satisfy the adjacency test in Sackett. And the court did, dismiss the case, but gave EPA an opportunity to amend its complaint. So that case moves on.
As we go to number 6, and this has to do with hobby loss regulations that are currently under review.
Yeah, and I may need a second here, Greg.
Okay.
To catch my voice.
Oh, no, absolutely. And this, of course, will have to do with a case that the tax court held the petitioner's agricultural activity that was a hobby, with the result that several $1 million of losses were disallowed, but there were several happenings as far as the case is concerned. And Roger, it's an interesting read as far as where this case is going, or the decisions, the judgments, that were made throughout 2024.
Yeah, what we have here is the hobby loss regs that are being reviewed as whether they are justified under the new opinion since Chevron has been repealed. Chevron deference has been repealed. Maybe these regulations on the hobby loss rules are not valid. So that's a big deal, and that's a big issue for agriculture. So that made number 6 on my list.
We go to number 5. This is the question as you deem it. When is income realized? But this has to do with a corporation that's located in India.
That's right, because there was a provision in the 2017 tax law, the Tax Cuts and Jobs Act, that created a one-time repatriation tax. And that had the effect of taxing you if you were a member of a controlled foreign corporation, and the definition of that is majority owned by people in the United States. You would get taxed on the increase in the value of your investment, whether you actually received a dividend or any type of distribution from the corporation. We're going to claw all that income back. It was one of the revenue raisers under the 2017 Act. And these people, these investors here from the U.S., in this India company that made tools, small tools for farmers in India, they got a $15,000 tax bill from the IRS, and they said, well, we didn't get any income. You can't tax that. Well, the Supreme Court said that it was constitutional. You could do that, but it was a very narrow ruling. But it does give us insight as to where the justices are at on the issue of, say, a wealth tax or a tax on appreciation in value. And they, in a footnote, said, Congress, don't read into our opinion that you can do something like a Biden millionaire tax or an Elizabeth Warren type tax on wealth. You can't do that. But this is a very interesting case in terms of when is income taxable and when is there a realization event, and when can income realized at the corporate level be attributed to the taxpayer. And if we had time, I'd break down where all the justices are at on that. But we may be pretty close to, in the right case, the court saying that there's no income that can be taxed until you have it in your hand. And that goes to the whole constructive receipt doctrine that farmers can get into, and it can cause problems for them in a number of different areas.
And another one, which is number 4, this concerns the EPA and looking at herbicides and some of their draft strategy that was talked about in 2024.
Right. The EPA did put out a draft strategy in 2024 designed to address their supposed failure to meet their obligations under the Endangered Species Act on a pesticide-by-pesticide, species-by-species basis, and change the way that they would register herbicides as well as pesticides. And the problem with this, Greg, is that they're going to apply those rules in any area where an endangered or threatened species has any of its habitat. Now, we might think that that's not a big deal, but the strategy is focusing on conventional ag herbicides in the U.S. on 264 million acres of farmland that they have identified being in areas where an endangered or threatened species has some of its habitat. So many farmers will be impacted by this if this is finalized. because more than 90% of species that are endangered or threatened have at least some of their habitat on private land, with almost 70% having over 60% of their total habitat on private land. So this has a bunch of rules in it with how you mitigate spray drift, setting up windbreaks, the requirement for hedgerows, hooded sprayers, reduction of application rate, a tremendous amount of additional regulation if you get caught by this. So that I have at number 4 on my list. And again, some of these, Greg, when we talk about herbicides, Clean Water Act, some of these other developments, a change in administration may mean, as well as the public lands rule, may mean that these things don't actually go into effect. So we will have to see what happens. 25 is going to be a very interesting year on the regulatory front for farmers and ranchers.
Yeah, most definitely. And that leaves us, by the way, with the top 3, that we will have, but we will do that next week. But and one extra one could, in some form or fashion, depending on where this goes, even though they've made a decision already on the Corporate Transparency Act, this could, the CTA could definitely still not be, to say the least, it's going to be heard from before 2025 is over with again.
Oh, and you may have just hit on something that might be in my top 3.
Aha. I didn't. That's called a tease, folks.
An unintentional tease.
An unintentional tease. Yep. All right, Roger, we're out of time, but as always, appreciate it, and we will cover the top 3 in the next program.
All right. Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.